everyone, Leslie Cornwell, Certified Nurse Midwife with Midwifery Business Consultation. This next section has to do with vicarious liability and collaborating relationships. A legal disclaimer we put at the beginning of all of our presentations. This information is for general and educational purposes only. The content is not intended to substitute for professional, legal, or clinical advice. We strive to keep our information as timely and accurate as possible, but make no claims, promises, guarantees on the accuracy of the information. The objectives of this section, we want to talk exactly what is vicarious liability. The students will be able to verbalize why it's really important for midwives in particular to understand vicarious liability and how that relates to collaborating physicians, hospitals, if there's ever a court situation occurs. The students will be able to verbalize the ways to reduce the risk of vicarious liability, and the students will be able to verbalize ways to improve collaboration with physicians by reducing that risk. So let's go back to the basics. What exactly is vicarious liability? It's also known in Latin as responsare superior, and it's holding a person or entity responsible for damages or harm caused by someone else. So more commonly, vicarious liability, if you're a business owner, any of your employees, you have vicarious liability for them. You're responsible while they're working under you for damages, harm caused to other people from your employees. It also has to do with some states. There's a lot of concerns with collaboration depending on if it's a supervisory relationship that the state regulations require. Vicarious liability, you can have a hospital, a physician, someone that could be held responsible for the care you're providing, even if they're not directly involved in the situation based on that vicarious liability. So that's where there's a lot of fear and anxiety with physicians and malpractice insurance carriers that they don't want to be named in a lawsuit for something that they may or may not have been part of the damage, the harm that was caused. Most commonly, people think of the employee-employee relationship, but there's a lot of layers of how you can be held accountable for someone else's choices being made. So why is this topic important? There's multiple levels for midwives. I think it's important for us when we're trying to collaborate with physicians, we're trying to hire staff, we're trying to make the best decisions for our practice. Vicarious liability comes into play more than we realize. As business owners, we want to hire our staff, we want to train them appropriately, when we want to have the correct policies. When we're looking for a collaborating physician, we want to have rock solid protocols, policies, agreements in place to help reduce that risk of vicarious liability to anyone that we could be working with. This coverage is essential for any, even if they're an independent contractor. I want to stress to people, just because they're 1099, you hired them to do services within your practice, it's still under the umbrella of potentially being sued for vicarious liability. So you just really want to be careful. You're hiring the best people, you're collaborating with the best midwives, the best physicians, you're having a clear understanding of transfers, collaboration, support for each other so you can reduce the risk of bad outcomes and that lawsuit, including vicarious liability. Secondary liability, it's just more of a form of strict secondary liability. It arises under common law. Sometimes the word vicarious liability and secondary liability are interchanged, so I wanted to bring them up. It has to do in a broader sense with the responsibility of what someone else does and they're violating certain negligent regulations, guidelines, standards, and you collaborated, you work with that person, you could potentially be held accountable for the care that they are providing. So here are some various tips for reducing the risk of vicarious liability. I always encourage people to seek legal counsel, make sure their agreements are rock solid with their clients, with their employees, with their collaborating relationships, so that it protects both sides of the party. Make sure your malpractice carrier has vicarious liability coverage to protect both parties, particularly even a medical director, making sure that there's good clauses to protect everybody involved, making sure you have rock solid written collaboration agreements. As soon as you start using the word supervisory, it puts a very different legal jargon on that relationship with an obstetrician or a pediatrician compared to a collaboration, a memorandum of understanding. Our whole point is we want to make safe transitions of care, but we also want to protect the the physicians that are involved in that relationship, not increasing their costs of malpractice, not increasing their risk of vicarious liability. Izzy from Contemporary Insurance is an excellent resource for midwives. He's an attorney and an insurance representative, and he loves to answer questions and help out people. So I always stress, go to Contemporary Insurance, ask to talk to the owner, Izzy. He can definitely answer a lot of your questions you may have about vicarious liability and any of these legal questions. So why does vicarious liability risk typically come up as a challenge for midwives? We've already hinted at it a few times. Centers based on the CABC requirements need a medical director. Many states require supervisory collaborating physician relationships in writing. Many of the state birth center regulations require a pediatrician, a hospital, an obstetrician to have in writing a supervisory collaborating relationship. And so for us, if we are asking someone to be our medical director, we're asking somebody to collaborate with us, and we're increasing their risk of vicarious liability, we have to create a win-win situation. It's very difficult to find collaborating physicians because of this concern and fear, and sometimes just misunderstandings with vicarious liability. Sometimes they think, as soon as you say you are going to collaborate and send someone a patient, if they never touch that patient and there's nothing in writing, they're free of vicarious liability unless they're a business owner and you have something in writing. And so sometimes I'll send midwives and potential collaborating physicians to Izzy to have a conversation so they can really understand, what would you do to cause vicarious liability? What can you do to prevent and reduce the risk of vicarious liability? So you want to compensate the collaborating physicians appropriately for that increased risk that they're taking on to support your practice. So how do you build strong relationships? Be proactive as midwives. Don't just say, hey, will you collaborate with me? Talk to them, have a presentation, talk about vicarious liability, show them your sample policies, protocols, talk to them about what you're going to take independently, what you would collaborate, what you would transfer care, what would speak with them, non-urgent, Monday through Friday, what would go to after hours at the hospital, the residency programs. Really have a clear expectations and build trust and relationships so they can really understand your practice, your flow, your philosophy, and how you're going to protect the patients and them from any collaborating relationship. So I think sometimes I hear midwives saying, a lot of times, I have a hard time finding a collaborating physician, and the first question I usually ask is, how did you try to get a collaborating physician? Well, I just called them up and seen if they'd collaborate with me, and they said no. And then I would always challenge the midwives, I would really love for you to schedule a meeting, take them out for dinner, create a win-win situation and reduce their risk, your risk, and the protection of the patients all at the same time. Because they're thinking about vicarious liability whether you are or not. That's part of their fears. So you have to be proactive to break down those myths and misunderstandings of what vicarious liability is. Get them connected with the experts, get their malpractice carrier legal team connected with the experts so that you guys can create a strong collaborating relationship that reduces that risk of vicarious liability as much as possible. So improving tips for collaboration, you really want to show appreciation for their time, their dinner, thank you cards, sending them as referrals as much as possible, have regular scheduled meetings. Not that they're babysitting you, but the whole point of improving a collaboration is to build trust, build relationships with the healthcare practitioners in the community. You want a long-term relationship and a great image with the medical community. It's going to drastically decrease your concerns of transfer, bad outcomes, lawsuits, complaints to the state when we improve our collaborating relationships. So take the time, overkill the kindness. They do not have to collaborate with you. Maybe morally they should, but legally they don't have to. So we have to create a win-win situation. So whether it's financial compensation, the value shown to the community of this need for safety, whatever angle you choose to go at, you really need to think in their situation, the hospital, the pediatrician, the obstetrician, what are their concerns and worries? And I'm going to be proactive in my initial meeting with them to nip those questions in the bud because I know they're going to come up. So just as an overall conclusion, vicarious liability is a major concern for anyone collaborating with midwives, covering as backup, taking care of their patients after they get sick. Obstetrics, unfortunately, is a high litigation specialty, and A lawyer is going to name as many people as possible. They're going to name the hospital, they're going to name the physician you collaborate with, they're going to name the midwife, they're going to name the business owners that have the staff involved. In time, vicarious liability is going to determine how much they really were involved in that care. Were they directly one-on-one given care? Was it a phone consult? Were they just in writing as a consulting physician, but they actually weren't part of the care of this patient? So there's going to be different levels of vicarious liability interpretation based on state. The whole point is you want to reduce the risk as much as possible for everyone and obviously give great care, but trust, collaboration, regular meetings, keep your policies updated, have really strong memorandums of understanding or collaborating agreements. Obviously, if your state requires a supervisory relationship in writing to get your licensure, you'll have to do that at this point, but the more you can make it a vague supporting relationship to each other, the better.